Assalamualaikum and hello everyone. My name is Narisha, and for the first part in the video, I will generally explain regarding on this topic. So firstly, the Federal Constitution is the supreme law in Malaysia and it guarantees the citizenship right. This can be seen in the case of ASEAN as the Sufyan LP Judge ruled that the Parliament and state legislature power is limited by the Constitution because Malaysia now adopt the doctrine of supremacy of Parliament. However, there is still disparity in citizenship, especially for the children who born to Malaysian mother with non-citizen spouses. This can be seen when the Malaysian father have more privilege and work less in receiving their children's citizenship. On the other hand, for the Malaysian woman who married to non-citizen man will face long waiting period and potential rejection of her child citizenship application. The concept of citizenship in Malaysia had a concern to us because the children of Malaysian parents should not face difficulties in requesting the citizenship, and any denial of the citizenship will affect the children's employment, education, and also legal protection. Citizenship also important as it fosters acceptance between the individual and also the state. And for the viewer information, Malaysia had also ratified the CRC and CEDAW as the post-treaties concern and highlight on the importance of the citizenship of children. Next, I will highlight on the 4 research objectives regarding on this topic. Firstly, to examine the case law and relevant provision governing citizenship eligibility. Secondly, to analyze the societal implication of discriminatory citizenship practices. Thirdly, to gauge public opinion for this issue through online survey. And lastly, to propose recommendation for legislative reform. Article 14 to 31 and second schedule of Federal Constitution outline the citizenship eligibility in Malaysia, and there are 4 ways to becoming the citizen of Malaysia, including naturalization, territorial incorporation, and registration where need the application to the federal government. Another way is citizenship by operation of law, where it's granted automatically and subjected to the second schedule requirement. Citizenship in Malaysia is awarded based on partner relationship that favor on the Malaysian father, where the children who born outside of Malaysia with Malaysian father will automatically granted citizenship by operation of law. This can be supported in the case of Muhammad Sadiq, as the case outlined the requirement for the citizenship, including be born on after Merdeka Day, outside the federation, and registered at consulate. However, there are issues arise, especially for the children who the mother is the Malaysian but the father is non-citizen, as they must register with the government under Article 15 Clause 2 of Federal Constitution. For example, in Temeli Tiamaka case, where her child can register at the Malaysian consulate in Hong Kong, and she must submit OPEC application due to her gender. Meanwhile, in Suana Kempi case, Malaysian mother married to the foreigner who gave birth to children outside the federation request a declaration that their child are citizen. The court interpret that Article 14 Clause 1 Clause B must align with the Article 8 Clause 2 that prohibit the gender discrimination. Justice Datuk Tahir interpret the Federal Constitution humanizing Article 8 on equality to Article 14 stated that the judges must protect constitutional ideals and fairness.
Assalamualaikum. My name is Nurul Anisha Zliana Mitazan, and I will talk about the societal implications on discriminatory citizenship practices. So, the law promotes several kinds of bias when it discriminates women by granting citizenship by operation of law to a child born outside Malaysia only to a Malaysian father. This means that a child born outside Malaysia to a Malaysian mother who are married with non-Malaysian citizens would be considered as non-Malaysian citizens, and these children would become stateless children in Malaysia. So the first legal and social difficulty encountered by stateless children in Malaysia is in terms of education. Article 12 Clause 1 of the Federal Constitution has removed all the stateless children from the national school system when the provisions only mention the word any citizens for the right in respect of education. This indicates that stateless children would not have the right in respect of education to enroll in a public school as same as the Malaysian citizen children. Next, in terms of formal employment, if these children did not get their own birth certificate or identity documents or do not share their stateless status before the age of 21 years old, they will forfeit their right to be registered as citizens under Article 15A of the Federal Constitution. As a result, they will be required to get a work permit in the same way as foreigners who are working in Malaysia do if they want to work in Malaysia. Aside from that is in terms of access to healthcare. Stateless children in Malaysia have limited access to healthcare due to variety of factors. One of the factors is stateless children in Malaysia is classified as foreigners as they did not have granted citizenship. As a result, healthcare treatment for stateless children in Malaysia are costly. Lastly is in terms of engagement in crime and substance misuse. Since many stateless children are not educated, they inherit the tendency to act according to their own desire without considering the potential implications because they did not know what is right and what is wrong according to the law. As a result, the stateless children become an easy targets for offenders who exploit them as mules to commit crime.
Based on the result of the survey that we have conducted through Google Form, it can be concluded that the majority age of the respondents are around 20s and the highest academic qualification is doctorate. The survey revealed that 41.7% of respondents strongly agreed on having automatic Malaysian citizenship, while 25% disagreed and 33.3% were somewhat unsure. For the second question, the majority, 66.7%, believe granting citizenship to these children would significantly alter the country's cultural and social condition, while 16.6% disagree and 16.7% are uncertain. This shows that our citizens concerned about country's culture and tradition would be affected. Moving to the next question, the majority of respondents, 58.3% agreed, 16.7% disagreed, and 25% were uncertain about the government's ease of citizenship for children born to non-Malaysian fathers in Malaysia. 50% of respondents disagreed with equal rights and access to public services for children of non-Malaysian fathers. 41.7% agreed and 8.3% were unsure.
Moving to the next question on the survey, I responded with revised opinion on Malaysian citizenship, law and gender equality. About 50% were certain if current law discriminates against women, while 33.3% disagree and 16.7% agree. Regarding gender equality in citizenship law, about 41.7% disagree, 33.3% were uncertain and 25% agree. Next, whether children born to non-Malaysian fathers should get citizenship to strengthen national unity. About 41.7% were unsure, 33.3% agree, and 41.7% disagree. Next, 50% agree that international pressure and human rights advocacy are important for changes in citizenship law, while 33.3% were uncertain and 16.7% disagree. This indicates various views on the need for law reform but also show a strong sense of patriotism in Malaysian society.
We have come up with 3 suggestions. Firstly, is to amend the provision in Part 2 of the second schedule of the Federal Constitution by replacing the term father with at least one of his parents. By implementing this amendment, it will further the spirit and objective of Article 8 Clause 2, which aims to eradicate discrimination against women in Malaysia. More importantly, it will address and rectify the deficiencies present in the current citizenship provisions. Secondly is to repeal or amend Section 17, Part 3 of the second schedule of the Federal Constitution. The literal interpretation of this provision denies citizenship to children born out of wedlock, as Section 17 uses the current status of legitimacy. While legitimacy can change if parents marry, this is however a case for non-Muslim parents, and that Muslim children cannot be legitimized this way. Therefore, it is imperative to adopt the perspective of Yang Ahmad Arif Nalini Paselamatan in the Siti AB case, which does not consider legitimacy a prerequisite for citizenship by operation of law. Last but not least is to amend Article 14, Clause 1, Paragraph B to include the word mother. This is to enable the child citizenship to be obtained by operation of law. Currently, Malaysian mothers rely on Article 15 Clause 2, which allow those under 21 with at least one Malaysian parent to apply for citizenship. Despite an interim procedure used to its registration, the process remains cumbersome and slow, with more rejections than approvals. Civil society organizations report that applications under Article 15 Clause 2 face delays, repeated rejections and inconsistencies, unlike the efficient process for Malaysian fathers under Article 14 that is usually completed within days.
In conclusion, children born to Malaysian mother and non-Malaysian father face a legal and humanitarian issue due to gender discrimination in Malaysia citizenship law. This law unfairly favor father, causing social injustice and denying children access to education, health and work. Public opinion on changing this law is divided, but awareness is growing. Proposed reform include first, replacing father with parents in Part 2 of second schedule. Second, removing Section 17 of Part 3 of the second schedule to protect children born out of wedlock. And lastly, including mother in Article 40 Clause 1 Clause B for automatic citizenship. These changes will eliminate gender discrimination, protect children's rights, and align Malaysia law with international human rights standards.